Collaborative divorce is one of the emerging areas of alternative dispute resolution. It is a process where several collaboratively trained professionals work with clients to help them resolve their legal disputes in a healthy and holistic manner. In a collaborative divorce, each party to the divorce must be represented by an attorney trained in collaborative divorce. The parties then choose and jointly hire a financial neutral and a collaborative coach to assist them through the process. The financial neutral is someone with a financial services background, such as an accounting, finance, or financial planning professional. It is their job to assist the parties in gathering financial information relative to the parties' case and providing the parties with financial models regarding the division of the parties' assets and debts. The coach is a person usually trained in counseling, therapy, or social work who uses their unique skills to assist the parties in working through hurt feelings, anxieties, anger, and the desire to retaliate against his or her soon-to-be ex-spouse. The coach helps the parties and their attorneys keep the settlement negotiations on track so that a complete resolution of the case can be reached. Sometimes the coach will refer the clients to individual or joint therapy and may have the parties' children meet with a counselor as well to help the children cope with their parents' divorce. As a part of the collaborative process, both sides agree to exchange any and all documents and evidence that may be necessary in order for the parties to make an informed decision without the need for extensive and expensive discovery. These documents and the evidence remain confidential to the collaborative process, so you don't have to worry about anyone sharing your private financial information or the evidence of either party's indiscretions becoming public knowledge. If for whatever reason the collaborative process fails, these documents and evidence cannot be used in the litigation process without being obtained as part of the discovery phase of litigation. The coach, financial neutral, and the collaborative attorneys involved cannot be called as witnesses, and your collaborative attorneys who know all this information will not be able to represent you in the litigation process and cannot share what they know with your litigation counsel. Number 1, it is a healthy, holistic approach to divorce. By working with the various collaboratively trained professionals, each party is able to achieve closure and a resolution of his or her case gradually over time and is able to obtain insight and understanding that he or she may have not had if the parties had chosen litigation as their form of dispute resolution. Number 2, it is truly less expensive financially in the long term because litigation is expensive, especially if the case goes all the way to trial. Attorney's fees and court costs in highly contested divorce cases with several contested issues can reach the tens of thousands. In cases involving custody, retirement, and division of business assets, attorney's fees and costs can be in excess of $50,000 per side. And at the end, both sides spent a lot of money and can no longer co-parent with one another because each had their say in court. If the parties had truly engaged in the collaborative process and made all the required disclosures, they could have resolved their case for one half of the cost and reached a better resolution for them and their children in the long term. Number 3, collaborative divorce allows the participants to have control over their outcomes. In the collaborative process, no one is making decisions for the parties. The parties are making the decisions for themselves. The attorneys, the financial neutral, and the coach are all offering input, information, and advice, but the participant is the one in control of the decision making. In the litigation process, the court is in control. An elected stranger, randomly assigned to your case, who will never know as much about your life as you do, will be in charge of making decisions about your children, your property, and your finances. Although your attorneys will do their very best to get as much information as possible into evidence, the judge will never be able to hear your full story and will make decisions on less than complete information. Because the rules of evidence don't allow your judge to hear everything you may believe is important to you. Personally, I would want to have as much control in the decision-making process as possible. Collaborative divorce allows clients to do just that. Number 4, as I stated earlier, collaborative divorce is a private, confidential process. If you value your privacy and would rather your information and indiscretions remain private, then collaborative divorce is your best choice. All litigated divorces are public record unless very limited circumstances apply that allow your case to be sealed. And 5th, litigation is stressful. Discovery, court dates, depositions, attorney meetings, mediation, subpoenas, and ongoing conflict between you and your spouse mean ongoing stress and anxiety for you. Unfortunately, while the court may resolve the legal conflict for you, it cannot resolve the emotional conflict and the stress and anxiety that divorce, particularly litigated divorces, cause. The collaborative process has at its core the idea that the parties will be able to resolve their emotional conflicts while also resolving their legal, financial, and custody conflicts. It is a completely holistic process and allows parties to have a healthy new beginning. If you're facing divorce or other family law matters such as child support, child custody, adoption, or more, we want to help.
New life, new directions, new beginnings.